It was founded by a lady named Alice Kitt. Stephen met Alice when he was a social worker back in the day. So Alice Kitt had a son who was born with Down syndrome, and back in the 80s, early 80s, she quickly realized there weren't a lot of services available to him. So she became a tireless advocate in the nonprofit community, did a lot with ARC, and developed Guardianship Alliance of Colorado. So when she passed back in the 90s, when Alice Kitt passed in the 90s, the board went to, at the time, Cerebral Palsy of Colorado and said, this is such a really important organization, we need to keep it alive, will you support us? And so that's where it's been since her passing, I believe in 96, I believe. So Cerebral Palsy now is Ability Connection Colorado, and we just celebrated our 70th year.
75th.
Okay.
Wow.
75th, yes. So it's also a long-standing nonprofit organization, and we provide services to individuals statewide with all sorts of disabilities, from birth to the elderly. Well, historically, Guardianship Alliance only used to be a volunteer program where we would pair individuals, most of them in a nursing home, who outlived family or didn't have anyone suitable to become their guardian. And we would recruit, train individuals who are interested in becoming their legal guardian. Since then, we've grown. When I first started 6 years ago, it was myself and a part-time administrative assistant. And now we have a full staff of 8. So we are doing so much more than just the volunteer program. A little bit about what we do. We do a petition assistance class, which is designed for individuals seeking guardianship in non-contested situations. That is designed to teach them A to Z, the court process, the court forms, the time, expectation, costs, how to become a guardian, how to petition, therefore you don't have to hire an attorney. We do obviously a lot of guardianship training, that's what we're here today doing. We still do have the volunteer program providing guardians to individuals who need them. But about 3 years ago, we contracted with Behavioral Health Institute, who is under the Office of Human Services, or Behavioral Health, Office of Behavioral Health through the state. And what we are doing there, we have case managers who are paid to become guardians for individuals transitioning out of the mental state hospitals such as Fort Logan and Pueblo. And so those case managers are assigned 15 individuals. These aren't your typical aging, someone with a disability clients. These are very difficult, high maintenance clients dealing with mental health issues, oftentimes dual diagnoses. So that has consumed a lot of our time. We are also developing new programs to assist APS in very similar ways, where APS, we all know they can't take every single case, they're on overload, so we are hoping to be able to assist them with our case managers, assuming some of that caseload for them. And then obviously one of the big things that's always in question is the Office of Public Guardian, which we all know is a dire entity that we need here in Colorado. I was part of the task force, about 3 years ago, and went nowhere. We were hours and hours of conversation, we did a role model. The problem with the Office of Public Guardian is that we are so far behind the game, and it's going to cost millions of dollars, and where are we going to get that money? Where is that money going to come from to assist these individuals? And when we started doing research, we identified at least 9,000 clients in Colorado who could use a guardian. Who are we going to say it's only the homeless? Are we going to say it's only those with mental health? Is it those in the aging population? Who are we going to serve? So it's an ongoing thing. I don't see it happening anytime soon.
Quick question, Office of Public Guardian, what is that?
Sure, so Office of Public Guardian is a statewide service where they have paid individuals becoming guardians for...
On the state level?
Yeah.
Okay, got it,
Yeah.
thank you.
Do they have any?
Do we have a
Is it
program?
actually happening?
No, it's not happening.
Okay.
Oh, we don't have a program here.
No, we are, so GAC, Guardianship Alliance of Colorado, we're the only known resource
Okay.
that provides that service right now currently.
Okay.
And we're on a very small spectrum, compared to what Colorado really needs.
And you said 15 cases, is that what you said?
For the case managers, yes,
Who
Very
work with your
complex.
office?
yes.
But those are only for people with major mental illness? or-
Correct,
Okay.
correct. So when that was developed, I was visiting a lot with APS and kind of following their role. What do their social workers have under their caseload? They have about 24.
Okay.
However, we knew taking these sort of cases, 15 is gonna feel like 24.
Right.
So, obviously, if we do expand, taking some of those easier, more acute customers or clients.
Easier,
We-
more acute.
If that's a real thing, then we can consider a higher number.
Right, okay.
So how many of those case managers are there?
We have two full-time case managers. We have a full-time administrative assistant. She's in-house. She does a lot of the phone work, copy work, that sort of thing. We have a contract attorney. We have myself. We have Lewis, who is the supervisor, trainer, kind of as duties are assigned.
You gotta have
Am I
one of
missing
those.
somebody? And then we have,
Trades, master
yeah.
of none.
yeah. And then we have several volunteers. I think right now we have 36 volunteers
Right,
Wow.
36.
serving, about 40 clients, freely, just,
So all of those 36 are volunteer guardians?
Yes.
they are,
Okay.
yeah. Well, and although they're volunteer guardians, they're still legally responsible to the courts. So they still have that legal responsibility.
It's been, and I'll segue into that component with our programs. That's been a hard sell or promotion to
Mhm.
get adults to become volunteer
Yeah.
guardians.
Mm-hmm.
Just recently, well, the last 9 months, we hired a lady who's getting a master's degree in social work, and she said it wisely. She said, "This is an incredible role for me. However, I think long-term, that's where your challenge is
Yeah.
for volunteerism.
Because what you want is a guardian for the rest of the
For the
person's life.
hopefully for the duration of their lifespan. And that has been a major hurdle. Not low, not high, but very high hurdle for
Yeah.
us.
I thought volunteer ombudsman was
I know, I
a
was gonna
high
say.
pressure volunteer, like,
Yeah.
wow, that's
Yeah.
that's
So
a
if you know any
commitment.
volunteers, or you know an individual that may fit the mold for a guardian, that's a huge referral for us.
Yeah, and that's a lot of what Lou does, is he really eases that process for those individuals. Because oftentimes when they hear court process, they're like, hey, never
Yeah.
mind, I don't want to be in that sort of situation. But knowing and understanding and educating them that we're here and we're not just going to say, okay, now you're the volunteer, good luck. So when we do appoint those individuals, they're designated volunteer guardians through our agency. So they're not just by themselves. And that's typed up on the order itself. So
Are most of the people that the clients, are they mostly, younger? I think, you mentioned cerebral palsy and mental illness and, some of the other things. Kind of what I'm thinking is that if you get a guardian who is committed, that they might be older than the person who they are the guardian for, and what happens when they start to, like the parents, people who.
yeah. Most of our clients through the volunteer program are those in the aging population.
Okay,
So dementia,
okay.
just physical frailty, most of them are in nursing homes. We don't right now service anyone living independently in the
Okay.
community. And those transitioning out of the mental hospital, that ranges from early 20s
Right.
to
Right,
80s,
okay.
90s.
But those are your paid
That's
case
correct.
workers. So you guys serve about 40 plus 30 people, is that right?
So right
Yeah.
now, we have 60, 60, what's 60?
A little bit more than
Yeah,
60.
a little bit more, yeah. Individuals that we serve,
60 wards then?
wards.
Okay. Do you have any volunteer POAs?
We used to, and we found that it's really hard to have a volunteer POA. What we were finding out, it was a one-time kind of thing, kind of deal, that they just needed a POA just to make a consent about one issue. They were maybe having a medical procedure and wanted a POA in place in the event something should happen. So that was really difficult for us to form, and how were we gonna build that long-term? Many of our volunteers said, what do we get out of that? We don't get much out of that, so we're not really interested in something short-term. We'd rather have that more one-on-one where we can develop a relationship with our client. And we can go ahead and move to the next slide. So our mission is to ensure that the rights of incapacitated adults are protected and that appropriate decision-making support is available to adults in Colorado who have impaired decision-making capacity. So what is a guardian? We talked about that. It's a legal process where the court deems an individual incapacitated. When doing so, then they appoint a guardian. Then that person has the legal responsibility to make decisions about their support, care, education, and welfare. So those really are the day-to-day decision-making things that they're doing. And it also includes things like placement. One of the challenges that our case managers have right now is placement. I mean, we just know that there's a lack of beds available, and when they do become available, they're gone like that, so.
Especially for the complicated ones.
Exactly, who have a criminal background because of their mental illness, really don't have any insight. And on paper, they look like a vicious lion, but really they're just little kitties if you get to know them. So, it's always a struggle for us. So a guardian legally then has that responsibility. And then also engaging with them. We always say that guardianship is a partnership, not an ownership. You're working with that individual, making decisions according to their capacity and what they can participate in. So if an individual has the ability to work part-time or go to school or live independently, then you should support that. A guardian should also consider the desire and personal values of the ward, and just remember that you're acting in their best interest and not yours. So a decision that you wouldn't make necessarily for yourself, you sometimes have to step back and ask yourself, would it benefit them?
Is there some sort of standard that, how often they need to be visiting with their ward?
There's not, right now, there's not a standard. What we tell our case managers, so they're pretty much involved.
They're very proactive.
Yeah, very proactive. At least, they're meeting with their clients at least twice a month.
Wow.
And they're, if not more, depending on the level of need and care. But then they're also very much involved weekly, whether it's by phone, picking up the phone, calling their clients, hey, how's it going? And then always there, every 3 months, their plan of care meetings that they have.
Okay.
And then they do the annual report to the court as well, right?
They do, yes,
Okay.
they do an annual report. So our administrative assistant, we have a tickler system where our administrative assistant will, every single case, whether it's a volunteer or a paid case manager, she maintains all of those due dates. And so what she'll do is send a reminder out 3 months in advance to the volunteers and case managers, your report is coming up, so here's some time to get it together so you're not late.
This is the report to the court.
It is, it's the annual Guardians report, which is a mandatory reporting requirement.
Can we ask some questions about that? I mean, I'm
Sure.
curious, what needs to be in that? Who reviews it?
Okay, so it is an actual court form, it's about
Okay.
9 pages long.
Wow.
A few years ago, the court was under scrutiny because there was a big audit, and what they discovered that the courts really weren't following the wards like they should. Where are they? Are they deceased? Where's the guardian? So they hired these case proceeding individuals, or case proceeding, I don't know what they're called, case proceeding clients, or what they do, their job is to review every single annual guardian or conservator report that's filed. And what they do is they compare it with last year to make sure that there aren't any major red flags or changes that need to be addressed with the court. That is asking, so that actual report, actually, I do have one, yes.
So they may see
okay.
something and that would trigger them to say, can you tell me more about what happened here?
Correct.
Okay.
Just tell them now, that way you can see it.
Yes, and I'm gonna actually, we actually have some handouts for you, and in there is an actual guardian's report.
Okay, great.
So, but it asks about the current information of the guardian and the ward, and have there been any changes of their address, or do you still wanna be the guardian? Their physical condition, social condition, mental condition.
Do they ask anything like, does anybody else put any information into that? Like, I'm thinking if somebody lives in a nursing home, do they ask the nursing home, how's the guardian doing?
No, they don't.
Just curious.
One of the things that they ask is visitation of the ward, so
Okay.
how often, what does that look like, is it a phone?
Okay.
Now, if you have any concerns about a guardian, the first thing that you should do is write, well, first, we're all mandatory reporting, right?
Right.
So we have to report.
Well, actually, no.
We're not.
Oh, you're not, really?
I'm
We're
buzzing
not.
now.
Oh, okay, okay,
Yeah.
so we are.
But we tell other people what they should do since they're
Right, so
mandatory.
mandatory reporters should obviously report to APS.
Right. Or law enforcement, yeah.
Our law enforcement, correct. So we do both. Write the court,
Right.
address the court, yes, and,
Okay.
and just outline your concerns, because not every guardian is a good guardian.
Mhm.
A lot of them are just not responsive, they, I wouldn't say neglect, but they just aren't available. When's the last time that you've noticed a guardian's been by to visit their ward? Those are some of the things that you all should be aware of. Are you trying to get a hold of the guardian because there's a decision that needs to be made and there's no response? Maybe the phone's disconnected and you don't know how to get a hold of them. Notify the court in writing, in detail, their name, the client's name, and then you would hope, assuming that that guardianship is held in the county where.
So you just call the county court and go, who do I need to send this to? Basically,
So
like for this
it's-
person who has a
right.
guardian, I'm.
It's the district court.
Okay,
and-
where the ward lives.
Yes,
Okay.
in the probate division.
Yes.
Okay.
Usually though, but some people can move around the state and they may reside in a different district, but their guardianship was originated
Yeah.
somewhere else.
Right, so what the courts would then, the courts, the judicial system has a statewide system where we can all look in the database and see statewide who's where. And
Okay.
that's with every single court case type, so,
So you could call up any court and say, this is the person, this is the guardian.
Yeah.
Who do I follow up with right now?
correct.
Okay.
So those people who you were talking about earlier who review the annual reports, are those like ongoing people or were they just during that audit?
No, they are now permanent
Oh,
positions.
that's great.
They've really cleaned house.
And what are
Yes.
those called?
They're case proceeding,
People.
yeah,
Okay, that's good enough. That should be easy to find.
reviewers, people.
CPP,
Yeah.
case proceeding people. So I'll just say right here before we'll take it just a brief moment. Would be the packet that we would give parents or anyone pursuing guardianship
Okay.
for an adult. So on the left side of this is informative information about guardianship. On the right side is the legal chronological documents per
Okay.
visit for a case.
Okay.
So you will see the guardianship
Report.
annual report in there, and if you remember where to put it back, that would be awesome. So-
These are for you.
But this
Oh,
is for
awesome.
you
Thank
to
Yeah.
manage and just kind of use as reference going forward. Great.
Do you have an extra one or did someone get one for Bill?
Yeah,
Okay.
I'll hold on.
Yeah.
Perfect.
And we can go on to the next one. Here in Colorado, we have dual responsibilities. We have a guardian and conservator, so guardian obviously is that day-to-day person. Conservator, again, the court is appointing someone to manage the funds or assets of an individual. We really don't see this with those born with a disability, reaching adulthood, needing a guardian. We really see this, the conservatorship necessary for someone who just didn't prepare either through a financial or medical power of attorney, and I'll go through what those mean here in a minute. So oftentimes we would see a conservator for someone who has developed dementia, could no longer manage their assets. They have a home, they have a bank account, they have pension, they have a vehicle. Those things need to be protected and maintained. Or it's like a traumatic brain injury. Someone has suffered a really bad accident and obviously is incapacitated and can't manage their own financial affairs. So the court would then appoint both a guardian and conservator. Same responsibility, meaning you have to file that annual guardians or conservators report every single year. And again, the court proceedings people are reviewing these reports as well. If the only source of income for the individual is going to be Social Security, that role can fall under the scope of a guardian. It doesn't need a conservator. Oftentimes we see that the facility will become the rep payee, or they have a rep payee already identified. And when we talk about assets, we're really talking about assets larger or greater than typically $10,000. Any questions? And we can,
A quick question, are there
Yeah.
two separate forms for the guardian and the conservator?
yes,
Okay.
yes. And everyone has on their CD, everyone has a CD here with all of the forms in Word document. They're both the guardian and conservatorship forms, but in the packet, we only print out the guardian. And we can move on to the next one. So why is a guardian necessary? Under the age of 18, the statute basically says that parents are unwilling or unable. It's completely different from custody, and it's completely different from adoption. At any time, a guardianship, whether it's for an adult or for a minor, can be terminated. But for an adult, and we can move on, it's where conditions that occur that substantially decrease an adult's ability to provide for their own health, safety, and welfare. And that's over the age of 18. So an instance where a guardianship may be terminated, an individual, again, has suffered from a traumatic brain injury, oftentimes with therapy, rehabilitation, just time in itself, they get better where they can regain their own ability to manage their own finances or day-to-day needs. At that time, guardian is no longer necessary or conservatorship, then the court can go ahead and terminate that. These numbers I think are probably dated, but what we found out probably about 5 years ago is that there are 2.1 million disabled adults who are victims of physical, psychological, or other forms of abuse and neglect. You can keep on going. And then 90% of those being abused or neglected is by someone that they know. So you've probably have seen this, I'm sure, firsthand, just being in the facilities and what those individuals look like coming in. What we found, so a little bit about my background, I started out with social work with Adams County for DNN cases, dependency and neglect. Then I went into the Denver probate court where I was the supervisor, deputy registrar. So I really had the ability to see firsthand a lot of these cases that were coming through, and now here at the Guardianship Alliance. But what we were finding is that financial exploitation was more of a concern than physical abuse or neglect. And what we were seeing, the individuals who were either held a power of attorney or appointed by the court were mismanaging the funds, and it usually was an adult child mismanaging mom or dad's money. One story, it was just so awful. So the daughter was appointed as the conservator, and the mom's home sold for about $350,000, and she was supposed to use that money for private care, spend down until she no longer had the money, and then she would have to go to state level. Well, what was happening was that the mom wasn't paying the private care facility, And when the court finally realized what was going on and got a copy of the bank statements, we saw this history of spending where she was out of mom's account, she was spending thousands of dollars every single day. She was taking her kids out to like these really fancy clothing boutiques. They would go out to lunch, they would go buy electronics, and then just this vicious cycle. Here's the caveat, is that her husband is an attorney who should have known better. So obviously, when the court did discover, her assets were almost depleted. And this case was so severe that it was actually referred to the DA's office for criminal charges. I don't know whatever happened, if they proceeded to press charges or if she served time or if even her husband was disbarred. But it was pretty serious. So we saw this happening a lot. I mean, that's obviously one of the severe cases, but even in a decedent's estate where an individual passes and people are just coming from out of the woods, just wanting a piece of the estate or entitlement to the property or money, we saw that a lot.
Did you read the article in the New Yorker about the guardians in, was it Nevada?
Someone mentioned it to me, and I have to yet read that.
Okay.
I heard it's great.
I haven't yet read it either,
Yeah.
but I think some of us have.
Yeah,
Yeah.
I read it.
Yeah, it's not a quick read.
Yeah.
Yeah, it's a typical New Yorker
Yeah.
piece. So I would definitely recommend printing it out, so you're not straining your eyes. But yeah, it's like an emotional piece to read.
Yeah,
Mm.
yeah,
Yeah, and it's pretty appalling what these people are doing.
yeah.
And I'm sure stuff like this is still going on too.
I'm sure I can sit here all day, and I even joked about writing a book about some of the stories that I heard in court. Some of them very sad, for some of them very comical too.
I think it's just a good, like, almost shock piece to
Yeah.
make people really think about what guardianship truly is.
Yeah.
Because it's not something to be taken lightly.
Yeah.
And
There are, like I said, there are some really bad guardians out there, and if you do have, most of them I would say are really just,
I think there's some really
Yeah,
great
absolutely.
guardians as well.
but you do have that handful that aren't doing their job, pardon me, or really overboard and dramatic case where, like the reading in the New York Times, or what was it?
The
New Yorker.
Yeah, the New Yorker.
Is there a difference in the responsibilities if somebody's a professional guardian versus private?
No,
Same
the
exact
only,
thing.
they're held to the same level of care. The only difference, one is paid versus one is not.
Okay,
Yes.
okay. Do you have any thoughts about professional versus volunteer? I mean, I'm just wondering if there's, we have a couple of people that have professional, but mostly not, so, and we don't know really how to.
Yeah, we are pretty fortunate that our volunteers are very sophisticated. And I think they do a well enough job, just as well as a paid fiduciary. I think the benefit of a volunteer is it's really one-on-one,
Uh-huh.
whereas a fiduciary has several cases.
Right, okay.
There's an individual, and I won't say any names, who has so many cases. She's a professional guardian, where I get a lot of complaints through our agency on the individual. And because they just feel that they're just not responsive, they're not meeting their needs, they haven't been by to visit.
The
they're-
ratio's too wide.
How much does it cost?
And that's another thing, there's no state set amount for a fiduciary.
So you could say
So
I'm
this
$300 an
individual-
hour.
This individual usually is appointed by the court most often because they, I'm gonna say they, because I don't even want to identify the sex, but they are willing to take on a case for less. So let's say $30 an hour versus $100 an hour. And so when the court is considering the estate of the individual, of course they want to go for the lower
Right.
amount. Obviously, we know that a professional fiduciary is paid from the estate, so that's gonna deplete them on our monies faster. I don't know, I think there's pros and cons to both, I really do.
Yeah.
I think for my experience with volunteerism with us as GSC is they have the opportunity to build not just the partnership, but the relationship with the individual. And whereas a paid guardian would be their ratio could be 1 to 30.
if not more.
Yeah.
Yeah.
And so how are you building a solid foundation of partnership and relationship with the individual? I have a volunteer, her name's Maria, she's awesome, but she gives me these weekly updates. And she's like, I just want to let you know that we had lunch together, and I just want to let you know that he kind of got caught smoking. I just want to let you know. But see, when you get emails like that, that's progress.
Yeah.
And I think that's the problem with the state is people are not responding because their workload's too much, and two, they don't have the time to do an email
Right,
of
right.
that type of detail.
Mm.
That's good.
Good point.
So we all know about the red flags, and you all hear about the complaints, I'm sure, of any concerns that someone has if they have a parent or a loved one in a nursing home or some sort of facility.
Oops, sorry.
So before considering guardianship, there are alternatives. There's a medical proxy decision maker. That is not a legal responsibility. It's really in an emergency situation where two doctors deem an individual incapacitated, and then they nominate someone at that time to make decisions. Usually we see it, like I said, in an emergency situation. However, as ongoing decisions need to be made, additional surgeries, treatment, placement, movement, then those medical professionals are wanting to see more legal documents. So that would either come through a medical or financial power of attorney, POA, or a guardian or conservatorship. A power of attorney, whether it's a medical or financial, you have to be of sound mind to execute into that instrument. So oftentimes when we're talking about an individual is already in the hospital, they're already incapacitated, they can't draft into a medical or financial POA. The only option would be guardian or conservator. So really, a medical or financial POA are documents for individuals like us planning for the unknown. In the event something should happen to me, I as the principal can name an agent to make decisions on my behalf. The nice thing about it, and we can go to the next slide, that as an agent, principal, I have the ability to sit down with that person I'm naming and say, these are my wishes, can I trust you? In the event something should happen, this is what I want done. Also, I can change it at any time. As long as I'm of sound mind and I understand what I'm doing, I can change that document. So if I've named my 18-year-old son as my financial POA, who's now, probably not a good choice, but who's now living at home, quit his job, asking for money and not paying me back, I've realized probably not the best decision. I can change it. So I am, and this is a true story, I am my mother's medical and financial POA. And because of her religious beliefs, she said to me, in the event I need a blood transfusion, I need you to say no, because I don't believe in it. Can I trust you? So if a doctor comes to me and says, Sarah, your mom is going to die, this is life or death situation, we need your consent for a blood transfusion, I have to be able to say no. And that's respecting her wishes.
Yeah.
So again, if something should have happened to my mom, where she didn't have that ability to have those critical conversations, who knows, they may have consented most likely to a blood transfusion to try to save her life, where she's completely against it. So obviously I've listed some pros and cons. There's really no court oversight with an advance directive. Sometimes it's just a little too late if something goes wrong, your agent is not doing a good job. Whereas there's court oversight in a guardianship or conservatorship. Again, we've had that ability in an advance directive to sit down and talk to that person. They can immediately step in. They don't need to go through the guardianship conservatorship process. Whereas we know guardianship conservatorship process takes time unless it's a true emergency. There's fees involved. So, any questions about those?
You may be covering medical proxy later, but since you brought it up already, I wanted to ask now in case I forget. I know that there's a new medical proxy statute, and I'm more familiar with the old statute where I think it said that once the decision that the proxy was created for has been made, it ends, the medical proxy ends. And if another decision has to be made, the whole process has to start over again. Does the new statute change that, and when does the medical proxy end under the new statute?
So now there's a doctor can be named as the medical proxy. So whereas before they could never be, and it usually was a family member or a friend, if there are continued decisions that need to be made, then a doctor can be named. Here's the thing that I'm seeing with that is a lot of doctors don't want to be put in that situation. They feel like it's a conflict of interest, where they're providing treatment, but they're also making a decision. So a lot of them are just, yes, it's legal that they can do that now, and sometimes they're just forced to. A lot of them are just saying, I don't want to do this. To me, and I'm not speaking personally, but the doctors are saying to themselves, this is a huge liability issue, potentially.
So if the proxy is a family member or a friend or someone who's been designated by that person's, party of people, when does it end under the new statute?
It's my understanding it's a one-time decision making, then thereafter they're wanting to see more legal sort of paperwork.
So say, oh, go ahead.
No, go ahead.
So say, for instance, someone had a medical proxy for an acute decision that needed
Sure.
to be made when they're in the hospital. When they return to the nursing home or assisted living where they may live, or they end up being placed there, the medical proxy shouldn't still have decision-making.
Usually not.
Okay.
There's a situation in one of the homes that Bill covers, who's not here unfortunately, but, because I know he would want to ask this. So the resident at the nursing home has a medical proxy, and the daughter is the medical proxy. It was done in another state.
Yeah.
The resident moved here for whatever reason, I don't know why. But now the medical proxy on the East Coast will not communicate with the nursing home. She won't make decisions, she won't call them back. And so the big question is, number one, does this resident still need a medical proxy? Has it ended? Who's supposed to make the decisions now?
So remember, medical proxy holds no legal power. It's usually that one-time decision. So she has no legal authority to respond or make decisions or even communicate. Now, if it was a power of attorney, that's something different. So she may have just said, I'm done. She's no longer in my state, I don't want to have anything to do with it, and she has the right to do so. So I think it would be up to the agents or the facility to identify, one, do they feel or does the medical professional feel that this person can't make decisions and really needs a guardian, and reach out to an agency for some sort of assistance.
Or can the resident themselves make the decision?
Absolutely. If they have the
Okay.
ability to comprehend and understand what that means, yes.
Okay.
And they can identify a person as well. So if they have a friend or another family member that they would want to become their guardian, if they're interested, then they can nominate that person.
Okay. Or a power of attorney.
Or a
too.
power of attorney.
Right.
If they can enter, if they're of sound mind and they can really understand that legal instrument, they can enter into a POA.
Mhm. Okay,
Yes.
great.
You may be getting to this, but can you talk a little bit about the limitations of powers of attorney at some point?
It's laid out, yes, so it's really laid out in the instrument itself.
Okay.
So you can have a very limited power of attorney that says you can only manage, if it's a financial, those related to my business and not my personal.
Right.
Or you can say, on a medical decision, you can only make decisions regarding my cancer treatment, but nothing other than. So I think as individuals like yourselves, or social workers, or doctors, you really need to read those instruments and check the date and who signed the document, and making sure you are connecting with the individual whose name is on the document.
Right.
I think oftentimes we take for granted, they show a piece of paper and you're like, oh, you just must be that person. We had a case, yeah, there was a case in probate court where they had a medical POA, and the date was dated way before there had been a diagnosis of severe dementia. So obviously we know that the individual did not have the capacity to execute into that sort of document. And the caretakers knew that. They knew the date of the diagnosis. They knew it was years back, but never took the time to look at the date of the instrument. And it ended up in court and became really ugly. But, and I know it's, like you said, you take your time reading, but it is important to understand what that document says.
Yeah, I mean, I think what we run into most of the time is that it's just, oh, you have a power of attorney and now you get unlimited.
Carte blanche.
Yeah.
Yeah.
You're sort of gonna make every decision, we'll turn to you, we won't even
Yeah.
talk to the resident.
Yeah.
Even if they still have all of their
Yeah.
decisions.
And the power of attorney also does that. I said she couldn't eat bacon, so what are you doing feeding her bacon? Like, just every kind of decision that's above and beyond, like who you can talk to on the phone and who you can, all of those kinds of things. And so that's something that we struggle with, I think.
And I was gonna say,
No,
in your caseloads and volunteerism, how many guardians do you work with or collaborate with? Is there any, or are you working with more POAs?
I think definitely more POAs.
Yeah.
Yeah.
Okay.
And it's kind of occasional when we even work with a guardian, plus we don't always know if a resident has a guardian or not because it never comes up.
Yeah.
Sometimes the complaint that the resident has is about the guardian, so then we obviously know that they have one. But, we don't go and look at the records automatically of every resident that we get a complaint from, so we may not know that they have a guardian. Sometimes that creates like an awkward situation if they do have a guardian, but
Right.
we
And I
just
think
deal
some
with it.
people use those terms interchangeably too. I'm the guardian.
Yeah.
Even though they're not. So.
Now, it's important to also remember that your POA does not have any authority until that person is incapacitated.
Right.
Yeah, okay.
So that instrument, whether it's legal, it is legal, they cannot consent if that individual isn't.
But again, it's important to read the document, because some POAs do become effective immediately, so now there are two people who can.
Right, it's
legally-
important to understand that document, yes.
Right.
Quick questions.
We should all have them written so that it doesn't take effect until we're incapacitated.
Yeah,
Yeah.
so. So is guardianship the right answer? What I can tell you is that there has to be an assessment made of the individual's functional capacity, and that's either through a psychological, psychiatric, or medical examination. One of the required documents when individuals are seeking guardianship is a supporting physician's letter that clearly describes the history, nature, and degree of the disability. When we're thinking about guardianship or even conservatorship, it's a huge responsibility, and that the court really is stripping away someone's civil liberty, and that's the right to make decisions on their own behalf. So they want to know that the person meets the legal definition of needing a guardian and that it's supported by a medical professional. So in your packets, on the left-hand side, you do have an example of a well-written physician's letter, just if you wanted to know what those look like. And then you also have some information about some of the duties, responsibilities of a guardian. Those are on the left-hand side. The rights of a guardian, the rights of a ward.
Oh.
One key factor is when we teach classes, especially to parents, because they usually want to say, well, what if the nurse practitioner will just sign off on the guardian physician's report or letter?
Yeah.
The court really frowns on that, and when you present yourself as a potential guardian, the physician's letter is your gold.
Yeah.
Because that's going to explain in detail the diagnosis of the individual.
Yeah.
And we've actually had to talk to doctors, sit them down, and revise to elaborate even more in regard to a diagnosis of an individual. And one of the things that sometimes has failed is letterhead.
Yeah. So, they all get busy, we know that they're busy, so I think what we were saying is that they'll oftentimes have the nurse practitioner sign the letter, and not to disrespect their knowledge, because I sometimes think they know more than the doctor. They know the clients better because they're with them more. The court, unfortunately, really wants to see some sort of doctor sign that. And then there are expectations, like it has to be on letterhead, it has to be signed, it has to be dated. Obviously, a diagnosis 3 months ago can be completely different or look completely different today. The prognosis, can they manage their own financial affairs, those sorts of things.
It doesn't have to be a psychiatrist or a neuropsychologist who does the evaluation and makes a statement about capacity. It can be a general
It
practitioner.
can be, yes,
Okay.
yes.
Does the court favor one or the other?
No,
No.
no. So for instance, those transitioning out of the state hospital, it's the psychiatrist writing the letter and not their medical provider, because they know their diagnosis or diagnoses best.
Right.
I'm trying to wrap my mind around all this, and I'm sure you've said this, but can you tell me, just so that I can make sure I have it clear in my head, what the difference is between a medical and financial power of attorney and a guardian?
So
Good question.
really nothing.
Oh, okay, good.
Really, they hold the same, it was so frustrating for the judge because a lot of people wouldn't recognize a medical POA. They wouldn't, or a financial POA. They just didn't see it as a legal instrument. Whereas the court was saying it holds the same amount of power as a guardian conservator. And you can have limitations in a guardianship and
Oh, okay.
conservatorship, just like you could in a
POA.
POA.
Okay.
So again, I think it's important to read both documents, whether it's a guardianship order or or medical POA instrument.
But the POA can sit dormant essentially, right? Maybe that's a difference, right?
Yes, so oftentimes that instrument doesn't become effective until that person is incapacitated. Whereas a guardian, that person already is incapacitated.
Got it, okay. All right, yeah, okay, that's what I thought, but I just wanted to be sure.
Plus with a guardian, I mean, you know, the court is the one who orders that a guardian be appointed.
Yeah.
Whereas with a power of attorney, it's
Yeah.
the principal who creates it and
Yeah.
it's not under.
That individual themselves.
Right,
Yeah,
it's
yeah,
not
yeah.
under the supervision of a court or
Yeah.
anything,
Yeah,
so.
yeah, right, okay, good.
And I think, I know that there are some decisions that a guardian can make that maybe a power of attorney couldn't, like placement. A guardian can decide where the ward lives.
Correct.
Whereas a power of attorney, it would be harder to do, I
Correct.
think.
So one of the things that we see with a guardian versus a medical POA would be that placement issue.
Okay.
Also, a guardian cannot consent or make decisions to an individual's psychiatric care or treatment or alcohol or drug treatment.
Right.
Oh, interesting. Those are just specific limitations of a guardianship.
Correct.
Exactly.
So if an individual doesn't want to take their psychotropic meds and it's not court ordered, then the guardian can't force them. Or they
I
can't
see.
say you're going back to Fort Logan or Pueblo because of your condition, unless they volunteer to do so.
Okay.
So, are you all familiar with the certification in court-ordered meds and treatments?
Vaguely.
So it's under the probate division that houses the guardianship, conservatorship, estate matters. They also oversee the mental health issues as well. So a court can court order an individual to involuntary treatment and psychotropic meds against their own will.
Oh.
And typically, how are they administered?
Yeah.
By the staff,
Like
whether it's,
injections or?
they can be oral or injections.
Oh, God.
However, a nursing home, even if they're a 2710 nursing home, can't, or I don't know if they can legally or not, but most of them say, we're not gonna do that, you're going to the hospital, and the hospital will do it.
So some will administer meds, some will have the mental health provider overseeing the certification come in and administer. Some of the clients actually go to the hospital and take their meds that way. I've seen it all three ways. If it's a court order where it specifies which drug, the amount, I've seen where facilities are okay with administering those meds.
Yeah, I think most facilities will do the pills, but if it's an
Injection,
injection
yeah,
against the
right.
person's will, they
Right.
usually won't do that.
Well, that makes sense though, because then otherwise the guardian could essentially order you to prison, really, I don't
Right.
know, or like to be
Right.
locked up, right?
Right.
So that doesn't,
Yeah.
okay.
So when we're working with those clients who are non-compliant with meds, obviously our support and our really safety net is that court order saying you have to take these.
Otherwise, they can refuse it.
Otherwise, they can refuse. We already know that they're gonna deteriorate, they're gonna be a problem, and it's gonna be really difficult. It's gonna be more acute care and crisis intervention for our case managers versus a guardianship role if they're not taking their meds.
Sure, that's a different role, isn't it?
Yeah, yeah.
Okay.
So does that mean that the patient needs to be harmful to himself and others?
Yes.
It's
It's the Medina law, which essentially says they are self-harm to others than themselves. I don't know the exact legal definition, but it's basically that. And there's a court proceeding for that where the individual will always have a court-appointed attorney and against the county or the city.
Does that happen in a timely manner, or do they have to kind of,
So
Wait.
the only person that can certify an individual is a doctor. So we see that usually where an individual is psychotic or maybe they have suicidal ideations, so they're rushed to an emergency room and they are holding that person for an amount of time. Legally, they can't hold them longer than 72 hours. They have to release them. If that doctor feels that they need to be evaluated longer than the 72 hours, they have to do a certification. They have to. So what that means is they fax that certification over to the probate county, which the county the client is in, and then the probate division opens a mental health certification case. At that time, then they can either terminate it within so many days, or if they want to extend that for additional treatment, they need to have a court hearing for a certification, mental health certification. So unfortunately, what we see, individuals will have so how it works is certification initially is good for 60 days. Then it has to be revisited. And then it's extended for another 60 days. Did I say 60?
Mm-hmm.
Yeah. Then thereafter it becomes long-term. It's every 6 months, and every 6 months it has to be reviewed by the court. We see sometimes that the court will drop the certification. They stop taking their meds because they feel they don't need them, they don't like the way they make them feel. They deteriorate, they become psychosis or psychotic, and they're back in the system again and they're recertified. So we see individuals who are recertified over and over, or we see individuals who've been certified since the 70s. We see both. Anytime that there's a guardian or conservatorship case open, then the judicial system communicates with the NCIC, National Crime Index-based Center. So then that person then could never, well, I couldn't say ever, they could not go in and try to get a license for a gun permit.
If they've ever been
themselves.
certified,
Pardon me?
if they've ever been certified.
Or even have a guardian or conservator.
Oh.
Wow.
Just have a guardian or conservator, oh.
Yeah. So, all of those guardianship cases, those individuals cannot go in and try to get a gun permit. It would be deemed on their, as a.
There's another difference between that and the POA then.
Yes, exactly. Yep,
POA can still get a gun.
And then I know sometimes people who have a severe alcohol problem, I've dealt with people who have called APS before, and I don't remember ombudsman, but you know, the issue is alcoholism, trying to protect someone from their own alcoholism, and so they try to get a guardianship for that. Usually doesn't work, and you know, no one can really force that person into alcohol treatment against their will, except for the court.
that's correct.
So, and usually, I think the person has to pay for that treatment too, and that's usually a huge barrier for that person, and so it's really difficult to get someone into alcohol rehab.
Yeah, guardian does not have that authority, like you said, only the court. And we've had an individual has the right to
Make that decision.
make that decision
Yeah.
and self-neglect. So we've had referrals where the doctor says they won't stop drinking and we need a guardian to make them stop. Well, I'm sorry, we can't. No one can, they have to want to stop. Or the court has to intervene and say, enough, you can potentially die here. We had one case that's very interesting. An individual wasn't eating, and I don't know how they were able to get it through the court, but the court ordered her into treatment. So there is something called an emergency guardian. Typically what happens from the time you file for guardianship, your actual court hearing's about 4 to 6 weeks out. In a true emergency, it usually happens that same day. But the emergency guardian will not exceed after 60 days. If it needs to be continued, the court will require an additional hearing. And in every single emergency case, the court will appoint that individual an attorney. Because they're not, at that point, they're stripping away that right that same day. They don't have time to give official notice out to the individuals about this proceeding, so the court will want to revisit that. Usually, I can give you an example, and I always go to like someone is so severely demented, they're living at home and they're doing bizarre things like putting socks in the oven, or they're taking off and getting lost in the car, and the police have to get involved. Obviously, the courts would consider that an emergency where they really have to remove that individual from their home and get them in a suitable, safe setting as quickly as possible. Too many guardians, I think that the only time that there should be one or more, usually when parents are becoming co-guardians for a child with a disability. Otherwise, we can go to the next slide. What happens, you all, co-guardians have that same authority legally, so we just need to want to know that it's a strong relationship. It usually gets convoluted when you have 2 or more individuals involved, so.
Would that same thing be true for medical and financial POA?
There's usually one person
Yeah,
named at that point.
yeah.
So, another, I guess, difference between. And courts usually frown upon 1 or more, or 2 or
2
more.
or more.
Yeah.
Makes it a lot harder.
And that's really all I have for you. This kind of goes into the whole legal process of petitioning the court and what that looks like. I can tell you that in every single guardianship proceeding, guardianship conservatorship proceeding, the court will always appoint a court visitor. So the court visitor is an individual, they're really the eyes and ears of the court to identify any problems before a court proceeding. So they will contact the person petitioning, and they will contact the individual needing a guardian or conservator and meet with them in person and visit the facility in which they reside, whether it's at home or a hospital, and ask them a series of questions. Do you want a guardian? Do you want this person to be a guardian? Do you want an attorney? And then kind of go over with the guardian, do you understand what this role means? And if they have any concerns, then they would notify the court through an actual court form of their concerns prior to the court hearing. Therefore, obviously the judge does not have the time to go in and make these sort of home visits, if you will, like the court visitor. And then at that time, if there are any concerns that need to be addressed, the judge knows ahead of time and is aware of any potential problems or serious
And that happens
concerns.
at the appointment of the guardian. Does it happen like
It happens not at the,
anytime there's an issue or?
it happens at the petitioning process,
Okay.
so not at the appointment time, so by the
Before it's appointed.
before. So during the time you are waiting, you've petitioned and you're waiting for the court hearing, in that time frame, the court visitor will go out and make a visit. Now, at any time that there are concerns, so if you all have concerns, or if any of your social workers have concerns, or nurses, what you can do is write the court then will appoint a guardian ad litem, which really is a fancy word for investigator. And then that person will go out and make an investigation and make any recommendations to the court about any
Okay.
potential concerns.
So the guardian ad litem is trying to find out whether a guardian is needed, or what's
No,
their
that's
main-
not their determination. They are
Okay.
really there to address any concerns. They're there to, so if you say, I have really, this person is just not responding, hasn't been by, they're gonna go out, they're gonna find that guardian, they're gonna ask them, what's going on? Why haven't you been by? Why aren't you responding? They're gonna identify the needs of the client, and then they're gonna report back to the court. Then it's ultimately up to the court to say, you are no longer suitable, you are terminated as your role. Or if you feel that an individual doesn't need a guardian, then you can let the courts know. I mean, that needs to be supported by a physician's letter that they have the ability to make those sort of decisions. But either way, the court will appoint a guardian ad litem.
So that case I had at the bridge where the daughter wasn't doing what the resident wanted, she was appointed a guardian ad litem.
Oh, okay. So that was before the permanent guardian was appointed then, right?
No, the permanent guardian was appointed and the resident had complaints about her.
Oh, okay.
I think we're talking about two different things, because
Yeah.
there's a point at which before the guardian is even,
So there's a court visitor, which is different from the guardian ad litem.
Okay.
A court visitor is during that process before they're appointed.
before it's even been decided.
Now, if there are any
Yeah,
other
okay.
additional concerns, then they appoint a guardian ad litem,
Okay.
And with the court visitor would make clear who they are, right?
of course.
Okay.
I think that's like, well, like, did somebody come visit you? I mean, somebody would talk to you about this whole process, and they're like, no, nobody came. You know, that kind of thing, and I'm thinking that's why you're asking, it's like,
Yeah.
people may not know
And
that
you-
that person was that
yeah.
person, and that if they had
Or they
something to
might-
say,
yeah.
they
Or they
could-
might just not remember
Right.
that.
Yeah. Right, they may not remember.
Mhm.
And I'm sure you've dealt with a couple of guardian ad litems or court visitors in the past in the facilities coming in and making visits with your clients or residents.
But what's happening in the instance where you have a certain person unnamed who's, you feel is not doing the best thing for their guardians? What do we call them? We call them wards.
Wards.
For their wards. Is the system working to catch that as a problem, or?
Now that they have the court proceeding people, and because of the scrutiny that they were under a few years ago, they're responding to just about every single complaint or
Okay.
concern.
Okay, good.
Do the wards get to see the reports that are being sent?
Yes.
to the court?
So they are required every single year that the person filing has to give a list of individuals identified by the court. These individuals have to get a copy, so the ward is one of them.
Okay.
The facility in which they reside would be one. Their primary care doctor would be one. Any family members identified. So if we want to go to if we want to go on to the next couple slides, right here. So where it says interested persons, these are a group of individuals identified by Colorado law who must be given notice of a guardian conservatorship proceeding. So at the beginning, during the petitioning process, obviously there's going to be a court hearing. They need to give notice to the doctor, or family members, or parents, or children. There's a court hearing on a guardianship conservatorship matter at this time, at this date. If you have any interest, you should be there. If you have any objections, you should say so. Once then a person has been named guardian conservator every single year, that person must give those same individuals a copy of that report, including the ward. They may not have the capacity to understand what it means, but they still are required to receive a copy regardless.
And who's responsible for making sure they actually get that?
The court proceeding, well, so when the person is signing that actual guardian's report, they are affirming to the court that yes, they indeed sent a copy to these individuals. And then what the court proceeding people are doing at the court side is they are looking at the court order reviewing who needs to get a copy and does it match who the guardian gave a copy to. They're doing that sort of detailed work with these reports.
So if we happen to know, for instance, that like a ward didn't get a copy, would that could be something we could contact the court about?
Yes.
Mhm.
And if you're not getting, if the facility, because the one providing the residential provider, they have to be given notice of one as well for their own records. So you should have one every single year. If you know that there's a guardian appointed, you should have one every single year in your files.
Might be doing some homework.
Well, I'd be interested to know if the homes get them, look at them, you
I
know?
have a feeling they just stick them in there and
Yeah,
don't even look at them.
yeah.
I mean, you can look at the example one, and it's pretty lengthy, and I know, but it really is important just to kind of read that, especially the first couple of pages, because that's gonna identify any concerns.
And it's additional resource for them.
Could we switch to POAs for a second?
Yeah, of course.
I'm trying to remember what, a long time ago before we decided to have you come, what the issue was with powers of attorney, but I think it was at least that there's a fairly new power of attorney statute that probably was enacted, I don't know, in,
About a year ago.
was it a year ago?
If we're thinking of the same one, it's now where a physician can be the medical proxy decision
Okay.
maker.
I think the power of attorney one though was like around 2010 or something, if I remember right. Do you know what the difference is between the statute before that and the new one?
I think the only difference is that they added the word durable. Whereas it used to be power of attorney, now they're really saying durable POA or durable.
Okay.
What does that mean?
Durable versus,
Nothing.
I really don't know, because they're this
Durable.
really the same instrument, exact instrument.
From my understanding, what durable means is that it only applies to powers of attorney that become effective immediately. And it's saying that if at some point the principal, the one who made the power of attorney, becomes unable to make their own decisions, that the power of attorney continues past that point.
Okay.
Okay.
So that
That
the
would
power of
make sense to
attorney.
me.
So kind of duration or durable.
Right, so it only applies to
Trying to make it
ones-
logical.
Yeah,
Kind of thing.
some of them only become effective when the person can't make their own decisions, and then it wouldn't make sense
That
in
would
that
make
setting,
sense.
but.
Yeah, that would make sense. But I don't know, since, I don't know any real changes to a power of attorney, other than that durable piece that I'm aware of. And that would make sense, because that was probably back around that time
Mhm.
that they started using that.
Do you ever do trainings on powers of attorney in homes? Because I think probably there are a lot more questions and issues with powers of attorney than guardianship, for sure.
We do.
More common.
Yeah, we do. We go all over. So if you ever want us to present to your facility, just let us know. We'd be happy to do so. We talk to a lot of social workers and doctors and hospitals and nurses and you name it. And really, you're right, it generates around the question, what sort of power does a POA have? What concerns as providers do we need to look for? What if we have concerns? Who do we address? What's the difference between a guardianship versus a medical POA? Those
Who
sorts
do
of
they
things.
address if they have a concern about a power of attorney?
The court, because the court can revoke a POA.
Okay, so same kind of deal. just a
Same
power
kind of
of
deal,
attorney.
yeah,
Okay.
yeah.
That's good to know. I mean, I think that, by and large, it's people who are just making every decision. And when we do trainings, we talk about, regardless if it's the power of attorney or a guardian, the first person you should go to about whatever it is you're talking about. Do you wanna, what kind of lotion do you wanna use? You should go to the resident first, regardless of who the decision maker is. Or do you wanna talk to this person on the phone? But typically
Yeah.
people don't.
And it really, knowing your client, identifying their needs and what their ability is to participate. Obviously, if they can make those simple decisions, go to them first.
Right,
I mean, there's no need, or if they consent to medical decisions on their own behalf, under a POA, go to them first. It can be a little tricky, where they could be, they can be functioning at a high level, but still have a guardian, and you're thinking, well, I know that the guardian has a legal authority, but I really do feel that they understand what they're consenting to. However, the guardian still has that legal authority,
right.
so you would have to get them involved. But if it's a simple thing like
Yeah,
meds or food, if it's not gonna mess with their diet or any allergies, religious beliefs, that sort of thing.
Yeah, I think we just see a lot of people overstepping that role and trying to make decisions that really should be the ward or the resident in our case. And trying to make decisions that maybe they don't really have the authority to do, or they might, but it's contradicting what the person would really want, things like that.
And I think it's okay to say, show me your legal authority. Or,
Oh, yeah.
or helping them understand, depending on how the instrument of financial or medical POA is written, this doesn't hold any water because they're not incapacitated yet. I respect what you're saying, but they're still very much involved and can participate in their own care. And that's where we're gonna go to for the time being.
yeah,
Sometimes you just have to be bold and honest.
yeah.
Just like we tell our guardians, because what we see sometimes our facilities are not reaching out to the guardians in cases. We had an individual who was falling over and over and over, who had pretty significant injuries, had a broken hand, and the guardian was never notified. And it wasn't until about 3 or 4 days later when the guardian went in to visit and saw that they had a broken hand, and said, well, why didn't you call me? Why did you take the person to the emergency room and you never called me? You
Yeah.
have my papers right here. So I think it goes both ways.
Yeah, it's one or the other,
Yeah.
it seems like.
It's a communication, and it again, it's really a partnership between all parties.
I know this used to be the case, and I think it still is, that if a court appoints a guardian for someone, that means legally the ward is incapacitated.
Correct.
Legally.
Mm-hmm.
But that's not true with a conservator. Let's say
Correct.
someone just has a conservator, not a guardian, that doesn't mean that they're incapacitated.
That is correct.
Okay.
So, let's say, I am in the service and I'm gonna be abroad serving our country for 3 years, and I need a conservator. Obviously, I'm not incapacitated.
Right.
So the
Just
court
need someone to
can't,
manage.
right, to manage. Now, why wouldn't I have a POA, financial POA? Maybe I want that court oversight, where I know that the court is reviewing those reports for me. So,
So if the person who's under a conservatorship objects to the way their money is being spent or preserved by the conservator, does that person's wishes override the conservator? Or,
it's ultimately up to the court, and there would be a court hearing to determine, to hear both sides really, and then determine how to proceed from there.
I think that, you know, even if people have a problem, the whole, like you're saying with your volunteers, the whole idea of petitioning the court and saying, I wanna have this looked at is really daunting and scary for people, even if it's, to me, totally obvious that they don't, you know, they have a right at least to have it looked at, or at least to voice their opinion, you know, but it's really scary for people to even approach writing a letter to the court.
Yeah,
So that's, I mean, that's something that I struggle with a little bit, because,
Yeah.
you know, we want people to say what
yeah.
their concerns are, what their opinions are, but it's a vulnerable position to be in, to have somebody making those
You don't
decisions.
have to put your name down.
Oh, that's a good point. I mean, the other thing is, I guess if the nursing home or whatever facility is getting copies of it, they could be voicing some concern or making a suggestion that it's looked at, but I don't know that they would do that all that often.
You never know, you could be opening Pandora's box.
Yeah, yeah. So, I mean, we can't do it without the permission of the residents, so getting them to do it is sometimes a little bit of a challenge.
Yeah, I heard that now facilities cannot write a letter of concern, is this correct? Or can you?
Facilities can't write a letter of concern
Like a skilled nursing home or,
to the court?
yes,
No, I think they can.
We had a,
Really can't.
this is interesting, I was teaching at, gosh, I don't even remember. No, it was another agency where, there's a group of social workers servicing different nursing homes. I think it was, Innovage. And I think they told me that they can't report.
That might be corporate policy.
That's what I was thinking, maybe
Yeah.
that's an
Oh,
internal
I
rule.
think actually, now that you say that, it was an in-house role.
That's awful.
Yes.
It is awful.
Like,
Yes.
that's exactly who should be having the
Yes,
concern, because they
yes.
know the resident the best.
Wow.
Yeah.
Wow, that's kind of
Interesting.
scary. Okay.
Don't quote us on that.
We're gonna go straight into
Yeah.
the social worker.
Sarah said.
Seriously.
We won't mention anything.
But I'm more than happy to come out and provide any additional training to your staff about the difference between guardianship, conservatorship, or,
What about families, or like, do you offer
Yes.
trainings periodically for families on POA, guardian?
we do it all the
Last
time.
Tuesday night, we had nearly had a 3-hour class.
Okay,
Yeah,
Would those
do you want,
schedules be on your website or
pardon me?
The
the
class
class
itself,
schedules?
it's a good question.
No, we just go based on everyone's calendar, so just send me an email, just like Stephen did to get us here, so. This is funny, so we've been so incredibly busy, everyone's been wanting us to present before the holidays, and last week we were on our way here, thinking we were supposed to be in Boulder. And we were supposed to be in Boulder at 6 o'clock, and I just happened to look at the driving directions, and we were almost on Churchill Road when I told Lou, turn around.
Going to Lakewood.
We're going to Lakewood.
Oh,
So, yeah.
Did you get there in time?
Yeah.
Yes, we
had
did.
some time. But we were presenting Pasco, and the audience were families.
oh, that's great.
Interested in pursuing guardianship, and so what bloomed out of that was 3 days later, we had two family members come to do the whole process, because their child's gonna be turning 18.
Yeah.
And, but I think they're the fourth.
Yeah.
An entire class for a number of families.
Yeah, it's been busy.
That's great. I mean, I wonder if, it could be almost like something that a facility does for their families who
Right.
have
That's,
people living there, because that seems like it would be, you would get a good audience.
Oh, yeah.
I think people wanna know, I hope.
We go
Hopefully the people that we have concerns about would not come.
Probably not.
well, and I'll say this, the final remark on my end is, we were in Colorado Springs with a few people, and it was so intimate and so hard for them to make those, to say or share those hard answers. It broke me, and I had to identify a little bit more about my own personal experience with my grandfather. Families can be intimidated by the whole process, especially the legal process.
Sure.
And rest assured, they're not alone, and that's what we do, is we do give them a huge peace of mind walking out of there, that they can do this. Statistically, $35,000 to $5,000 for a probate court attorney to do this for a family. And on our end, we can manage that under $400.
Wow.
400, 450, depending on the court visitor fee. But we also have learned that Pasco and other agencies have helped waive those fees for their family members that they serve.
Oh,
So it's something to think about,
yeah.
and how to present this to those who you're serving. And
So I have a question for you all. I'm very familiar with the role of an ombudsman, but I was kind of sharing with Lou that role, and maybe one of you don't mind just kind of sharing what your role as an ombudsman is, overseeing a facility or concerns.
Take it away, Erica.
I'll start, but, chime in. It's basically, specific to resident advocacy. And we're here specifically for residents, not for families, not for facilities. So, I guess that's kind of where it starts, and it's federally mandated, so there's an ombudsman everywhere. And I'm sure you work with a variety of different programs. So Dr. Cog is 8 counties. We're alone in Boulder County, just serving our own. So all assisted livings, all nursing homes, we're required to be there. We have a lot more presence here in Boulder County, just because we're lucky to have the staff and the support of the county so that we can be there more often. So it's kind of like a balancing act, we're there more often, and hopefully that's preventing things from happening and giving people more of a visual of who we are and why we're there. And I think one of the things that you guys during your presentation that kind of caught my eye is like that the guardian and the power of attorney, they're supposed to do what's in the best interest of residents. And the phrase that we often use is the expressed interest, because it might not be in their best interest. And so
Sure.
that's really what we're advocating for, is even if you don't agree with it, then we really need to be paying attention to what the resident wants,
Correct.
regardless of whether it's like you were saying with your mom, blood transfusion. That's what she wants, not necessarily what the doctor or the medical professionals will want. So that's the big focus of us. And then the other big piece of it is confidentiality. So we don't talk about what the residents talk with us about without their being on board with it and comfortable with whatever action we're gonna take. And so that's a huge piece of it, just because, people sometimes want that safety in talking with us about whatever the concern is, and like we mentioned, we're the only ones who are exempt in the AAA from the mandatory reporting law. And so that's for that reason, so that people can talk to us about things that are happening, really serious abuse or exploitation concerns that they have without the sirens coming down down the hall. So that's a big piece of it too, which is to say, I think people kind of, their eyes get wide when we say that, but it doesn't mean we're gonna leave it alone and not do anything about it, but it's just so that it's a safe place to kind of talk about, how do we wanna handle this? What's gonna be the best way? We talk to people a lot about, we can report this and here's what's gonna happen when that report happens. So they just have the support and the confidentiality of the ombudsman during that time, so. What else?
We also do a lot of training on resident rights in homes,
Oh, okay.
and that's for residents, for staff, for family, whoever will listen. We also take quite a bit of calls from people who are looking for long-term care, because we visit the homes on a regular basis. We know them pretty well, and so we can help people find the right fit. So that takes a lot of our time too, is consulting with people.
Much more often than, the resources that are there for people are typically Medicare.gov for, it's the 5-star rating system, or the state surveys, and those maybe happen every year or a year and a half, and so we're there every month at the very least. And so we can give a really much more timely picture of what a home is like. You said something that made me think also.
We support resident councils in homes.
Yeah.
We try to attend all the meetings if we can in all the homes that we go to, but if, a resident council isn't functioning very well, like they don't have any officers at all, and so it's the staff who run the meeting, that's not ideal. We want it to be a resident-led meeting, because it is a resident meeting. Then we support the residents in beefing up their resident council. We do that a lot.
And we also do a fair amount of consulting and answering questions about resident rights in general, like, I get people referred to me from facilities, like they could be adult children, or they might have power of attorney or something, who want their parent to be in restraints or something, so talking about resident rights and why it wouldn't be appropriate to use restraints and things like that, doing education around resident rights, aside from just in a training setting.
Well, and I think that, unfortunately, part of, when we talk about this kind of stuff, we really are only seeing the problem cases.
Sure.
So I tend to get kind of skeptical about all of it, and, of course, we don't hear about it when it's going beautifully, and everybody's doing a great job, it's not an issue, so we hear about the horror stories that you see in court too, so.
Yeah.
It's really nice to be able to talk about how that process should go. I'm really happy to know about the reporting system especially, so. Yeah.
Thank you.
How much does it cost per person? One last quick question maybe. So if you serve like 60 people and you have a model that you're serving the needs of the people that are your wards, and do you have a number for that?
We don't charge. So it's all volunteer based, unless it's under the case manager, which that individual is paid to become that.
I guess my question might be, what's your annual operating budget divided by 6?
How much does
I
the
was-
person
I'm following you.
Sorry.
And you don't have to answer that, I'm just curious,
Yeah.
because it seems like a model that works.
I think luckily for us, our case managers can assume so many cases, and then we also the volunteer-based. Otherwise, we wouldn't be able to operate. Just because we are a nonprofit, I mean, we are small,
Right.
although it's ACCO, historically, cerebral palsy is a big organization. And we do get some financial support from the contract that we have with behavioral health.
Okay.
Yeah.
Good.
Do you know anything about the, I don't know if it even has a name, but there's an elder law attorney, I think in Boulder County, who is starting a project to provide guardians for people who need them, but they are attorneys, I believe, but they're doing it basically on a pro bono status for these people.
I think
Do you
you
know
have
the
funding to
attorneys?
pay for professional guardians.
Oh, is it?
It is,
Say
it
that
is
again, I'm
professional
sorry.
guardians, actually.
Yeah.
What was that? It's a,
The attorneys that are doing this, they have funding, I'm not sure where the funding's from, but they use that funding to pay for someone to have a professional guardian.
oh, interesting. Do you know the name of the attorney?
Rod Felzine is the one that I know of.
He's the contact to go through that, and they'll take something like, I think they might have maybe 12 cases, I'm not really sure. But they have a certain amount of funding, and if you apply to have one of their guardians represent you, then that funding goes to pay that guardian. It's a professional
Interesting.
guardian that they hire to do it. It's called like the exact same thing as the state one. It's like the pilot guardianship office or something like that.
How do you spell Felzine?
I believe it's Felzien, I think.
That's what I was.
I wonder if it was the same
Oh, I thought it was
individual
Z-E-N-E.
Pasco was,
It might be, I don't know.
he had a flyer in the packet.
I don't think so. I don't
I'm
think
gonna
he's out of,
cross-reference.
yeah, I don't think he's out of Boulder County, but I have his name, and he's an attorney.
Actually, Bill, one of our, the volunteer ombudsman who can't be here, is also an attorney, and he knows Rod, I think. Well, I know that they've had a lunch together, so I think they know each other.
Oh,
But
great.
he probably could give you more information.
Yeah,
if
I'm
you
just
need it.
kind of curious. It's always good to network and know, and
Sure,
knowledge
yeah,
and
for
let
sure.
people know what's going on out there.
Because when I first heard about it, I thought maybe this is like a precursor to an Office of Public Guardian for Colorado, but I don't think that's what they're thinking.
It's
I
the
don't
same thing, except they have money.
Mm.
And the state one doesn't have any money, so
Very,
it's,
very
it would be
small
basically
level.
what they're, yeah.
Yeah.
But, yeah, it's a professional guardian, and I do think, kudos to your volunteers, because it's
Yeah.
such a high caliber, it's like ombudsman, like we talked about. It's just incredible that, people are willing to do that, but it also, I can totally see how the volunteers have a better relationship with the clients than a professional would, because they're doing it because that's what they want, I mean, it really is.
It makes so much sense,
Yeah. They have a passion versus the,
yeah.
And more so maybe
Livelihood.
just the calling too, and
Yeah.
I worked for a nonprofit for 15 years locally, and you struck a chord, and I think as a whole, I think we earn the right to listen to our people, to our residents, to our wards, and we do that in time, so you build trust.
Right.
And so when you talk about, hey, there's potential of the sirens coming down, when we break that trust and we lose it, it's a sense of failure, and that's what we avoid as a GAC, is we continue to build those relationships by listening to people. Maybe they're not coherent, but 80% of life is what do we do? We show up, right? And we, whether we just make a difference by passing on some McDonald's or listening to something that we don't understand.
their delusion.
Their delusion.
Right,
It's a big one.
It's a big difference.
Yeah.
It's a
really
big
is,
difference,
yeah.
but you show up, and that's what our program does, and that's what you're doing, so kudos to you as well.
Thanks. I always think like when we do our documentation, there's a checkbox that we have to check whether the concern was validated or not. And I always put validated, because whether or not it happened for that resident, it did.
Absolutely.
Regardless of what we think, or the staff might think that's not true.
Or
We've
the
had
staff.
conversations about that.
All right, well, we may call you again.
Yes, Stephen has my contact information, my email, so.
Yeah, this is great, and I know that Bill was like, really wanting to see you guys, so
Yeah,
we may,
he was.
we may
And what's
see you
Bill's
again.
last name again?
Nagel,
Nagel. I think that sounds familiar to me.
really?
Yes, I do know several elder law attorneys just from court. I mean, obviously not a lot of them go to Denver, but I do
Yeah,
know.
he worked for the DA's office here in Boulder County for a
Yeah.
while, and,
Sounds familiar. I'm
He
sure
was there for a
he's-
long time, wasn't he?
actually, yeah, I think he
Yeah.
was,
Yeah.
I'm sure he's frequent down in Denver a few times.
Yeah.
possibly. Well, thank you for coming.
Thank
I
you.
really
you.
appreciate it.
Thanks for
Yeah,
having
that
us.
was great.
Yes, absolutely.
Very
That was
informative,
good.
yes. I feel like I'm beginning to understand. It's so complicated.
It is,
Yeah.
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 It's its own little animal for sure.
Yep, yep.
That's how I look at Social Security. I don't understand it.
Or Medicare.
Or, yeah,
Parents
Yeah, we
one
got a
that
lot
was
of
like,
Yeah.
before we came in here, did you guys see Gia was in there doing a Medicare consultation, and I was like, I just get kind of worked up even listening to her talk.
She's another attorney that we have, she's a Medicare counselor,
Yeah.
Oh, okay.
and
All right, well, thank you so
Yeah, thank
much.
you.
You guys know
Thanks a
where
lot.
you're at.
Thank you.